Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on explanation 3 to section 147 which was applicable before 1st April 2021 and the same concept is appearing as explanation to section 147 after 1st April 2021. The issue before the Honorable Punjab and Haryana High Court was that if the notice under section 148 is issued to the assessee on some points where the income of the assessee has escaped assessment, and during the assessment proceedings the assessing officer feels that no addition should be made on those points, but he comes to know that some addition should be made on some other points. So whether he can make the addition on some other points, if he does not make the addition on the points which were there in the reasons, this issue has been taken up by the Honorable Court in the case of Mehak Finvest Private Limited, Commissioner of Income Tax versus Mehak Finvest Private Limited, and this case is reported in 367 ITR at page number 769. The date of the judgment is 17th July 2014. The assessment year involved is 2000-2001, and in the present case the assessee has filed the return of income at nil, which was accepted under section 143 subsection 1 intimation. After that, the notice to the assessee was issued under section 148 and the addition of an amount of rupees 47 lakh was done as unexplained share application money in the hands of the assessee, for which the reasons were not recorded, and for which the reasons were recorded, no addition was made on that point. When the assessee was before the CIT appeal, the assessee's submission was that in the present case the addition has not been made on the basis of section 148 notice for which the reasons were recorded. So according to explanation 3 to section 147, the assessing officer can make the addition only by issuing the fresh notice. The assessing officer cannot make the addition on other points until and unless he makes the addition on the points for which the notice under section 148 has been issued. The CIT appeal gave relief to the assessee on this point. When the matter was before the tribunal, the assessee filed the appeal before the tribunal. The tribunal also upheld the order of the CIT appeal. When the revenue filed the appeal before the Honorable Punjab and Haryana High Court, the court said that the jurisdictional High Court in its case Majinder Singh Kang versus Commissioner of Income Tax, which is 2012 judgment and which is reported in 344 ITR at page number 385, the court has held that the assessing officer is free to make the addition on any point even if the addition is not made on the basis of the reasons which have been recorded for issuing the notice under section 148, and in that case even the SLP of the assessee has been dismissed by the Honorable Supreme Court. The court also discussed the case of Honorable Bombay High Court in the case of CIT versus Jet Airways, which is 2011 judgment, which has been followed by Honorable Delhi High Court in the case of Ranbaxy Laboratories versus Commissioner of Income Tax. The court said that because those cases are decided by Honorable Bombay High Court and Delhi High Court, and since the case of the assessee is of Punjab and Haryana High Court, in which already the jurisdictional High Court has decided against the assessee, so in that case the revenue appeal should be admitted and the court sent back the matter to the tribunal to decide the case on the merits. Friends, this case is very important with due respect to the Honorable Punjab and Haryana High Court if this view will be taken, because the court in the present case said that there is nothing mentioned in explanation 3 to section 147 that if the addition on the basis of the points for which the notice under section 148 is issued is not made, then the addition cannot be made on other points. This is not specifically mentioned. Friends, if this point is to be taken, then it means that the assessing officer will issue the notice on any ground and then he will make the addition on the other grounds, even if he is not making the addition on the ground for which the notice under section 148 has been issued. If that will be accepted, then in that case the learned assessing officer will have the very wide power which is not as per the mandate of section 147. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus Finvest Private Limited, and this case is reported in 367 ITR at page number 769, and the date of the judgment is 17th July 2014. Thank you, friends.